So we're going to get started. Welcome to the Judiciary Committee Subcommittee on HB 283 relative to rental application fees charged prospective tenants. So we are going to get started with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Okay, so we have 5 members of the subcommittee, and if there's anybody from Judiciary that would also like to join with us, that'd be great. Certainly welcome to. Representative DiLorenzo, Representative Horrigan, Representative Kenny, and then Representative Tripp, who is absent right now. So we are going to get started. So I first want to call on the prime sponsor to lay out the path that this bill has taken and set the stage. Representative Reed.
Thank you, Mr. Chair. Happy to set the stage. So HB 283, the original bill, sought to put a cap on application fees for rental units of $35 or the cost of doing a background and credit check, whichever was less. This is in keeping with a lot of similar laws on the books in over a dozen other states. Some states have outlawed application fees outright. The landlords in those states have not gone out of the landlording business. Many states have capped it at 25, 35, 55, in that kind of range. So our housing situation, the reason, the impetus of putting this in is our housing situation has been so severe in this state that our vacancy rate has been near 0.6% is the last number that I've heard. And this has created a situation that unduly favors landlords, so that they've managed to make application fees themselves a revenue stream all on its own. This is unlike any other industry, because in every other industry, when you're trying to get customers in, you incorporate those costs as costs of business. That's free market. And then you make up those costs through your normal profits. But in our situation, landlords didn't just stop at having application fees. In many situations, they would have empty units or sometimes no units available, advertised, and just bring in application fees. And with people being so desperate, they were able to not only increase those application fees, but rake in dozens of application fees in a month that would actually exceed the cost of even what they would have gotten from a tenant renting a unit. So not just that, but they've started recently doing things like holding fees, which are in the hundreds of dollars, renewal fees, which really didn't exist before so much. It's just been all over the place, kind of predatory towards tenants who are in a desperate situation, which I don't think is how our free market is supposed to work, not unduly favoring one side of that two-side equation. It's kind of similar to selling life rings to a boat of sinking people, right? So anyway, so the bill was in, there was much discussion, we had multiple amendments, and eventually it was retained. I have worked with the very gracious chair of this subcommittee to come up with one amendment. The people who have been advocating for this didn't feel like that was necessarily sufficient to address the entire problem. So we have another amendment, and it is up to you all to decide what the best path forward is between those two amendments or some new creative thing. To explain those amendments, the amendment, and I am on both, the amendment that Chair Alexander and I are on states that, first of all, a landlord will disclose in writing to a prospective tenant before accepting the application fee what the criteria of a successful background and credit check would be, so that tenants are not just throwing their money on something where they have zero chance of being accepted. The second thing is that a landlord, if they do not rent to a prospective tenant, has to return anything beyond the actual cost. So that's an actual background check, credit check, and documented administrative fees. That was kind of the nebulous part that a lot of people took objection to, because what is to prevent a landlord from saying that it took 10 hours at $50 an hour to process an application? And then finally, it does say that nothing in this paragraph shall require the landlord to conduct one of those checks or prohibit them from accepting someone who doesn't pass those checks. And that's kind of important, because even if you put forward a disclosure saying, well, this is my minimum criteria, you can still cite this RSA saying, I can still accept you even if you don't pass this criteria, but I'm letting you know what I consider to be acceptable. And that is to kind of cover the landlord, but also to let tenants make that informed decision of whether or not to proceed forward with paying an application fee. So I think that the Alexander Amendment, the Reed-Alexander Amendment, does improve our current situation. The Reed-Kutab Amendment is identical to the Reed-Alexander Amendment with one addition, and that is a cap. Knowing that especially some of the members of the Senate who would hear this were objecting to the idea of capping at a specific dollar amount, because that wouldn't be growth proof. We changed it to a percentage of the monthly rental amount. And after much discussion with interested parties, we settled on 7%. So yes, the landlord has to return anything above and beyond their costs, but they can't take in more than 7% of the monthly rental amount. Just so you can wrap your head around that number, if it's a $1,000 unit, it would be $70 for the check, which I think the going rate right now is $65 anyway. If it's a $2,000 unit, the cap would be $140 at that level. And there was one other piece that is escaping me, but that is the functional difference between the two amendments.
So thank you, Representative Reed. Let me ask you, the Amendment 2288, the one I'm not on,
Yes.
if the rent is $700 and it can't exceed 7%, would that even cover the cost of a background check?
I mean, yes, because a lot of places, so for the most part, background checks are like $10 or $15. And like I said, there's states that have outlawed them completely because it's such a small amount that we're quibbling over compared to the amounts of rent that landlords get. So yes, but I would challenge the chair to find me a $700 unit.
We're working on it. But I worry that when you put something in law like this and then the prices of everything goes down.
Oh
then
my
you kinda
gosh,
struggle with it.
please. If the housing market were to crash like that, then I would gladly put in bills to strike everything.
I know a few units that are going for that. All right. Any other questions for Representative Reed? Okay.
Thank you so much, Mr. Chair.
Okay, so now I'd like to call on any other interested parties before we start discussing this. So I know Nick Norman said he was interested in speaking. So would you like to go?
Thank you very much for the opportunity to speak. There's a lot more happening on this than I was aware a few days ago. So it's a little confusing as to talk about which amendment, because there's three that I'm aware of now to talk about. There was an amendment that was, I think it was 2268, and I believe it was Representative Joseph Alexander and Representative Ellen Reed that was putting that together. So that's what I prepared my testimony on. I also see there's an amendment 2286.
2286 is the one that I'm on, and then 2288.
I see that. This 2286 has addressed a lot of our concerns. So depending on what you're working with.
Where primarily this subcommittee is looking at 2288 and 2286. Representative Reed, do you have another copy of that amendment? The older version that has Representative Greason on it, 422, is another one I have, but we're not looking at that one. I'm not.
That needed some
Okay.
Yeah.
So I think those were minor grammatical changes. 2286 is the one that I'm looking at.
Okay. So let me address 2286. First off, in terms of the idea of putting something into the RSA that housing providers could not make application fees a profit center, we're okay with that concept. There's a few things in that amendment that I looked at that would be really troublesome. One that's still in this 2286 is end of line 10 through 11, and the criteria for a satisfactory criminal background and credit check. That's very hard, if not impossible, to nail down in any kind of brevity or specificity. There are, I think, I'm sorry, I should look at this. I did a quick search on the internet about how many federal crimes there are. There's 5,199. It's just unfeasible to document with any clarity what's acceptable, what's not. A housing provider is going to look at a total picture. They're going to look at what comes in for criminal reports. They're going to look at the credit report. They're going to look at landlord references. They're going to make a judgment on the entire picture. They need to do that because every situation is completely unique. Every person is unique. If we were to have to put into some kind of codified specific criteria, what would happen is the housing providers would make the criteria more stringent to protect themselves and to protect the residents. And you would, in fact, make it much, much harder for marginal applicants to get approved. For instance, now there are some housing providers that just say, we will accept anyone of a credit score over a certain number. So that's simplistic. And in some respects, it makes their job of approving application easier. It also typically throws out a huge amount of people applying. In my office, we don't do that. And most landlords that I speak to don't do that either. Because when you set that credit score bar too high, you've eliminated a large amount of your potential renters. But if we have to put in specificity, can't hardly say that word, with criminal background checks and credit reports, you're going to find that it's just going to make it worse and worse for marginal applicants. So in this 2286, if that was stricken out, I think, now I'd have to review it with my team, but I think we can accept the rest because all of the other objectionable pieces are taken out of that amendment. Some of those other objectionable pieces are in this previous amendment I looked at. It said that the overage over the actual cost would have to be returned to the security deposit within 30 days. That would require, in some cases, landlords to do something illegal by New Hampshire law. In New Hampshire law, a landlord cannot accept more than a 1 month security deposit. It's not uncommon that when someone applies for an apartment, they say, here, I'm very interested and I'm going to give you the full security deposit when I apply. If there's some overage and now we have to return it to security, that's telling us we have to do something that's illegal by security deposit law. So if you were looking at that previous amendment, you'd need to strike that piece out. There's also, I'm sorry, there is one other piece to this 2286 that is problematic. This is amending RSA 540-A:3. That's prohibited practices in security deposits. The penalties that go along with that are what landlords often refer to as the $1,000 per day penalty. Don't you think that's like extreme for a security deposit that, or an application fee that's in the range of $25, $50 typically? I've heard in these testimonies that housing providers are sometimes charging $100 application fees. Personally, I don't know any landlords that are doing that. But this has to be moved either to a different section that doesn't impose those draconian fees, or RSA 540-A:4 does put limitations on those fees. So you could address that section to limit the penalties out of this $1,000 per day fees. Also, there was, in a previous version, part of it said, shall disclose in writing and also in any advertisement. I see that that's not included, the advertisement part, in 2286, and that's good, because to put that huge amount of documentation of trying to define what is acceptable criteria or not would swamp an advertisement with volumes of data. And imagine trying to put that on a for rent sign in a window. I mean, it's an advertisement. So I'm glad to see that that was taken out, and I hope that it would stay out. I think that's the major concerns. And again, it's a little bit unclear because we've got so many different versions, but if you're working with this 2286 with those changes that I mentioned, I can run it by my team, and I think that we can work with that.
Thank you, Mr. Norman. Are there questions for
I'm
Mr.
open for any questions,
Yeah,
please.
are there questions for Mr. Norman? Okay, thank you.
Yep, thank you.
Is there anybody else that would like to add their 2 cents in here? Please. And just introduce yourself for the record.
Yeah.
Thank
Hello,
you.
my name is Julie Smiley. I gave testimony the original hearing for this bill, and I am a former employee of the Front Door Agency, where I served as a case manager for people struggling with housing crisis, and we also served as landlords with over 60 housing units for low-income individuals. And the CEO of the Front Door Agency, Maurice Werble, is here today and would like to speak to from the landlord perspective. But I want to focus on the perspective from a renter, having worked with people for almost 5 years who are struggling with the housing crisis, which I think we all know is way out of control in New Hampshire right now. It's affecting the workforce. People cannot find staff because people can't find affordable housing in the state. One of the huge barriers for people, and there's many barriers, this is only the tip of the iceberg, but it's important to address, is application fees. People, because of the lack of available units, renters are having to apply to 20 apartments before they are approved, especially people with housing vouchers. And the costs are extremely burdensome for people struggling on a low income. They don't have the excess funds to pay for multiple application fees. It is an absolute huge burden to these families. And it has also become a profit center for property managers who I was reported received reports from a number of them that received 50, 100 applications for every apartment. They're accepting an application fee from every single person that applies. And 90% of those applicants, they don't even run a credit check or a background check on because they have so many, they just feasibly couldn't do it. So I think that key in whichever amendment we choose to go with is putting a cap on application fees and ensuring that that cap is reasonable to protect the renter, and at the same time ensure that landlords, at least their minimum costs are met. There's a cost to doing business, and we can't always expect in every field of business that those costs are always going to be met upfront by the consumer. Some of those costs are sort of rolled in and you make your profit down the road. Given that we have 60,000 too few units in New Hampshire for people to rent, there is no end in sight for the housing crisis. The landlord's income is protected. I can't see there being an imminent crash, certainly not in the rental market. I'm not sure how they could build 60,000 units that are affordable within the near future in the state. So the other key point to mention here is the exception to the background check issue that was being discussed previously, that we are asking property managers to disclose the broad reasons they would be looking at within a background check. Is it a past felony conviction? Is it a minimum credit score? And clearly within the language here, it states that nothing in this paragraph shall require the landlord to conduct a criminal background check or credit check or prohibit the landlord from renting to an applicant who does not pass the criminal background or credit check. So it's protecting the landlord that we actually thought was important after receiving communication from a kit lord who sent in an email and expressed concern if they prescribe a criteria for background checks, then how could they make an exception for somebody, say somebody that has a felony 20 years ago but has exceptional credit score, and they would be willing to sort of make an exception. This covers that, the statement in here covers that and allows for that flexibility. And I am concerned about keeping the cost as low as possible so that only the hard costs from the property manager are covered. Even a 7% bill is concerning to me, but if people are only paying one fee and everybody else gets their money refunded or ends up not being charged a fee, that may be acceptable. But I still am concerned about lowering the bar, so increasing the minimum amount people are going to charge. I think those are all the points I wanted to cover, and I want to thank everybody for their time and energies, especially you, Joe Alexander, and Rep Reed, on making the efforts to address this, which is honestly such a huge issue for people who are trying to rent apartments in New Hampshire right now. So I'm happy to try to answer any questions.
Thank you, Mrs. Smiley. Are there any? Okay, Representative Horgan.
I guess my first question, my question is, many of these rental housing units that are available, and actually some are being built finally after many years of no action, are owned by entities which are, owned by other individuals or entities who have many different, might have multiple different entities actually renting apartments out. So have you found that if somebody's renting, trying to find an apartment with multiple entities that have interlocking ownership, that the owners are charging them multiple application fees, or are they just charging them one when they're looking for multiple units owned by the same group?
My understanding would be you would, if it was, say, a property manager that owns multiple different facilities. You are applying for an apartment within a specific facility, so your application and your application fee would only apply to this building over here, not this building over here. Was that
That's how
question.
I thought it was, and
okay?
not necessarily how I wish it was, but that's because I
Yeah.
know, like in my community, there's an organization, there's an out-of-state company that's bought up many properties in my part of the state, and they are actually a member of Nick Norman's organization. I think if you look at the property records, there's several different entities which are all owned by the same company. So like, so I'm sure that's the case in Nashville and everywhere else too. Thanks.
Other questions, Representative Kenny?
Thank you for taking my question. In your experience, can you just tell me like the range of what you've seen charged for application fees currently and maybe the average?
I have seen 0 fees up to 250 fees for $250, and hold fees can be even more than that. Sometimes they're asked to put a whole entire security deposit amount down as a hold fee, and the average cost of an apartment in Nashua, a 2-bedroom, is $2,000 at this point in time. Did that answer your question? Yeah. Okay.
Representative DiLorenzo?
Thank you, Mr. Chair, and thank you for taking my question. Ms. Smiley, you mentioned that there was an abundance of landlords collecting fees and not renting the units out. So the landlords are making a profit. Do you have any background stuff on that? Any data, research, or anything?
I don't have data or research. I have anecdotal evidence from clients that would call us and tell us that they had paid fees to somebody and then that person just disappeared. There's nothing to prevent anyone posting an ad on Craigslist right now saying I have an apartment to rent, getting pictures, posting them up there, accepting application fees. And given that the rental market is such, with such too few units and such demand, people are definitely taking advantage of that. And I think even if it happens a handful of times, it's something we could address by putting limits on application fees, at least in part.
Thank you.
Well, I mean, what would prevent somebody from doing that is they'd be convicted of fraud. So, I mean, there is a court system that will eventually settle that. I guess my question is the intent of this legislation is to prevent landlords, housing providers from charging too much and not giving the money back. So I'm asking you, with this amendment that I've collaborated with Representative Reed on, do you think that the landlord should not be able to keep the cost of the credit check, the cost of the background check, which sometimes they're taken, sometimes they're not. So if there's no background check, that money's going back to the applicant, and documented administrative costs?
The documented administrative costs is something that's of concern to me because it's a very broad statement, and I am concerned about some of the soft costs of renting, i.e. showing an apartment, hourly administrative fees for checking credit, for checking landlord references, and the other time that might be spent could be rolled into that. And that's my concern with the administrative fees, unless we can really spell it out, what those fees could be. But I think that's a difficult thing to do.
I mean, surely like a landlord would not say, I'm going to get paid $50 an hour to process this credit check. And if this happened, I would think that the courts would be like, all right, that's kind of ridiculous. Like if this was ever adjudicated.
So I think that in my experience, especially the large property management companies that are often out of state and have thousands and thousands of units, are not looking at things from the perspective of the tenants. And it has become a huge money-making business for landlords, and it's of huge concern to me. I don't think that, I understand many landlords are trying to do the right thing, but there are also many in any sort of business like this that will take advantage and try to maximize profits, especially when shareholders may be included. Just those maximizing profits issue is a concern for me, and I've seen it a lot in working with the population that doesn't necessarily have the resources to take somebody to court. They would be relying on legal aid. And a lot of these people struggling, frankly, simply focusing on what they're going to eat for their next meal, what their children are going to eat, where they're going to sleep that night. They are not going to have the capacity to pursue a legal case to try and get $100, $200 back. It just does not happen. They are struggling often to fill in the forms necessary to receive their benefits on an ongoing basis.
Okay. Any other questions? Thank you. I see a lot of merit with the not overcharging and making a business out of this. So if you have evidence of any kind, if you could let the committee know about that, because I'd like to see if this is a widespread issue or
As I mentioned, it absolutely is, and Maurice Werble can probably also attest to it. We haven't been collecting data on that, but anecdotally, I know of many people that have been in that situation.
Thank you.
Thank you very much for your time.
Is there anybody else that wishes to testify? No.
Good morning. Thank you for having me today. I'm Maurice Werble. I am the CEO of the Front Door Agency located in Nashua, New Hampshire. Today, I am actually speaking on behalf of those we serve and also as a landlord ourselves. We currently own 67 units of housing to serve the lower income to moderate income families in Greater Nashua area. One of our programs that I really want to highlight today that is affected specifically on this bill is our security deposit program. We issue annually nearly $100,000 in security deposits to families. Since July of this year, we've issued 26 security deposits totaling over $40,000 to date. And of that, the average has been $1,562, with the highest request being $2,650. Most of the families who have applied for security deposits for us, they've had an income of about $40,000 in annual income for a family of 3, are mostly single parents, and the average number of apartments they've had to apply for before getting this apartment has been over 8 to 9 applications they've had to submit. Some of the families have been pushed out of current apartments because landlords are selling properties and they're given 30 days to move out. Obviously, they're now in dire need of finding new places, and they're putting applications in everywhere, and the fees have been so exorbitant it's actually set them backwards without the ability to even come up with a security deposit for a new apartment. These fees, even at the 7% amendment that was suggested at a security deposit of $2,650, that would still be a fee of $185 that a landlord could charge. I think most of our families could not afford that. So what I would love to see as a landlord for us, we understand that there's a cost of doing business. We obviously want to have the best tenants, the ones that will pay the rent every month, the ones that don't have felonies on their records. And of course, doing a criminal background check, I feel is a cost of business if that's what we want for a tenant. So for that, I think it's important, and we would be absolutely in favor of recognizing that and disclosing that to our tenants so that we're not taking funds from them to say what we are looking for in an applicant, but having that there's always exceptions to every rule in the bill, which this bill clearly highlights. So with that, I would love to see, obviously, the lowest administrative fee. Representative Alexander, I think your amendment is great. If we could put some type of limit on an administrative fee, whether it's 1% or 2% of the total rent that could be charged, that would be, I think, would help a lot. And I don't think the landlords would necessarily object to that. I personally would not, although we don't charge anything, obviously, for our clients when we're doing that. Also, we received support from the Greater Nashua Chamber of Commerce, has submitted a letter of support of H-Bill 283, and a letter was sent to Representative Alexander on behalf of supporting this bill because it does affect the business economy as well in Nashua. Our housing encampments are growing. Industry is finding it hard to get workers because of, again, they're applying to several apartments, some that do exist and some that don't. So we appreciate any support in getting something passed to protect everyone involved in our community. Thank you. Any questions?
Thank you very much. Are there any questions? Go ahead, Representative Horgan.
Yes, thank you. So you've been on both sides of the,
Correct.
you're working on both sides of the landlord-tenant divide. When do you, and I'm sure it takes a lot of time, and time is money, you know, to show the apartments, do the credit checks and all that. But when you're doing that, are you, I mean, obviously both parties benefit, but you are primarily providing the service to the front door agency rather than to the tenant? Is that probably a correct view of it?
Correct.
Yes. All right, thanks.
Any other questions? Okay,
Great.
thank you.
Thank you so much for your time.
Is there anybody else that would wish to speak on this? Okay, so I'm going to open it up to the committee. Could I get some thoughts from my friends across the aisle on what has been said today and give me some feedback on specifically my amendment, Representative Kenny?
Thank you, Mr. Chairman. So regarding the administrative costs, you just got a suggestion for language. I was wondering how you felt about that.
I'm concerned with the capping it with an arbitrary number. I don't like the 7% number. I don't like. I think I feel comfortable enough relying on the courts to really set a precedent if there is some abuse in the law. But I think when you have documented administrative costs, I think a judge can see through when it's like they're just trying to keep the money as opposed to they're trying to run their business. So I don't like throwing an arbitrary number in there, but I think if they can document it and prove that it is like just time that it takes to process it, I think that is a reasonable thing.
Can I follow?
Yep.
So you keep bringing up the courts, but a good point was brought up that a lot of these tenants would not be able to afford the costs of going to court, which is expensive. So how do you mitigate that issue with what you just said?
Well, I mean, New Hampshire legal assistance is here too. So I think that in some of these cases would be brought on behalf of tenant or groups of tenants, right organizations, things like that. But I don't see a world in which a landlord would get away with this for a very long time without it being like taken care of.
One more?
Precedent set. Go ahead.
So this is going to the other amendment because you brought up 7%. Does language that follows that, unless the landlord provides documentation to kind of prove if they need to go higher than caps, does that not make you feel more comfortable with having caps?
I'm just not in favor of the like putting a number on it.
Understood.
My position.
Thank you.
Yeah. Representative DiLorenzo, do you have anything?
Thank you, Mr. Chair. And I have a question. It's kind of glitchy. For the Alexander Amendment, last paragraph, line 14, states that nothing in this paragraph shall require the landlord to conduct a criminal background or credit check or prohibit the landlord from renting to an applicant who does not pass the criminal background or credit check. And my concern is a fair housing concern. I believe that under the federal fair housing regulations that all properties owners are subject to require that applicants be treated equally. For instance, you would not want to, let's say, of the Smith family and the Jones family. For the Smith family, you run credit check, criminal background check, and landlord references. Then you have the Jones family. For that family, you don't do any of that screening. And you accept the Jones family, but not the Smith family or vice versa, then, you know, I would think things need to be equal, other things being equal. That's my concern.
I think, and to answer your concern, I think the Fair Housing Act really protects the discrimination based on protected classes. So if there was any inclination that a landlord would not rent based on somebody's race or sex or something like that, that would be covered under fair housing. But I think in general, the landlord has the ability to conduct a background check or not, and rent to somebody or not,
Mhm.
and they can't just not rent to somebody because they're a different color than them.
Legally, correct.
Right.
Yes. Thank you.
So, Representative Horgan, do you have anything to add? Go
Um,
ahead.
Well, I'm somewhat uncomfortable with the whole notion of charging people, especially people who don't have anywhere to live and probably don't have much money, a fee for a service which actually doesn't benefit them directly. I mean, if they get the apartment, that's wonderful, and hopefully they'll be happy there. But I'm not sure why. I understand it's a real cost, but I'm not sure why the landlord shouldn't be paying for that out of the rent, out of the income from the business, rather than expecting these people who are out on the street and have no money to pay for it. There seems like a little unfairness involved, and also talking about the documented administrative costs. Well, first of all, once again, the service is being provided to the landlord, not to the tenant, but also, and the tenant, if they're accepted, will be paying a very large amount of rent, probably more than they can really afford, and also many times, like, for example, the woman who sent us the email, and I guess I won't mention her name, even though her name did get mentioned because I don't know much about her specific situation, but often, they're a sole proprietor or they have an LLC that they own with a few other investors. So they have a dual role. They have a dual role both as, both as an employee, either of themselves or of the entity they're running for, and as an owner. So I'm not sure really why they're. It just seems a little strange to expect the applicant to compensate them for that. So that's I just find something seems just a little bit abusive. I understand the need maybe to have a token fee, and even the 7% of the month's rent, that seems pretty steep, but that's fair. But I really don't know whether it's fair to expect the applicants to pay for the process, pay the full cost of the processing their application. That just seems somewhat fundamentally unfair. Although I'm certainly willing to compromise on a token amount, and maybe even that percentage is acceptable. But so I feel a bit uncomfortable with some of the language I've been hearing from the landlords. Even though I recognize they do deserve to make a profit, they do deserve to make a living, and it's not an easy job. I've dabbled in it myself. It's not. There's a lot of work involved. And the other thing, and one other thing, we sort of mentioned $50 an hour is an unfair amount, and that is certainly beyond the capacity of the average person who's looking for an apartment to pay. But actually, if you're making a decent middle class income, most of these landlords, hopefully, they are making $100,000 a year or more, which divided by 2,000 hours of work a year is $50. I know. I mean, I feel sort of dumb saying that because I'm paid $100 a year plus mileage, but certainly, actually, the $50 an hour you mentioned is not excessive in terms of what the recipient is getting. Well, certainly it's excessive in terms of what the applicants can afford. So I understand this is a real cost, but I sort of feel like this should probably be paid for out of the rent and out of the rather than expecting the prospective tenants to pay it before they even get the apartment.
Okay. Thank you. So, my question is, where's the committee at on? There's been a lot of landlord-tenant bills in Judiciary. In my opinion, this is probably one of the only ones that we can find a middle ground on. So I'm looking to the committee to see where we're at on Amendment 2286. I personally don't think I could support anything else other than that, but with some minor changes to it. So the only change I'd make to 2286 would be to cross out line 10 and 11, the criteria for a satisfactory criminal background check, if any. So the disclosure of the fee, there must be a disclosure of the fee, and then if there's a background check or criminal check done, that can get taken out of the fee. But if there's not a criminal or background check, that goes back to the applicant, minus administrative costs. So I personally think that this solves the problem, the anecdotal problem that we've heard from the public, and it doesn't add any or much more undue burden on housing providers. I think that they're, so I kind of leave it up to the committee. So we have to report back as a subcommittee to the Judiciary Committee. So if this, I mean, obviously, if we took a vote right now, I think I'd be outvoted. So if there is anything you'd like to add, that'd be great. Cam.
This is a question for you, and I don't know if you can answer it because you don't want to speak on behalf of the members of your caucus, but how do you think your caucus would react to the Reed-Alexander amendment with the changes you just said?
I think with the backing of housing providers and other people, I think that we could get. I mean, if all stakeholders are on board, I think that it should be relatively easy.
I'm,
Representative Horgan.
one thing that came up, which with the criminal background check, I'm actually reasonably comfortable with letting that be subjective because, you know, if, like, because, you know, like what we heard about the, for the person who had a low credit score, but then they were told, and who knows if it's true, but she believed it, that this person never uses credit cards and pays for everything in cash and hence had no credit history, which that's certainly fine. That's certainly fine if that's what you believe the case to be, to rent to the person rather than somebody else with a higher credit score. And also with the criminal background check, depends on the nature of the crime and what you feel comfortable with having it. So you might be okay. Somebody has a felony for something that doesn't really necessarily make them a bad tenant versus somebody might have what might actually be a lesser charge, but involves like violence or something else that you find that you just don't want going on in your units. You should be free to accept some people with criminal records and some who doesn't. Probably every landlord will have a different opinion about what they're willing to risk have going on in the units and what they don't. So that's fine.
Representative Kenny.
I don't know if this is appropriate, Mr. Chairman, but is there any chance the Democrats could caucus for 5 minutes?
Go right ahead. We're gonna recess for 5 minutes. I'll be here.
Thank you, Mr. Chairman.
If no.
record, I think we would prefer the original bill, but in the sense of compromise, I think that online of your amendment on line 13, moving the word documented to before the word background, so it applies to all background check, credit check, and then adding the word reasonable in between and or an administrative.
So we don't cap a hard number, but we put reasonable.
Correct.
I'm okay with that.
Yeah, and then we'd be satisfied.
Okay, so I also want to cross out. Is Representative Reed taking notes, or do we have to? Because she would run over to OLS. Okay, so I want to cross out line 10 after the amount of the fee, cross out and the criteria for satisfactory criminal background check, if any. And then the other thing I want to do is move this from A3 to A4. That is away from the penalty section. I need to go into the RSA and look at it. Nick, does that move it from the penalty? Does that solve your penalty problem? Penalty problem. Go ahead, just turn your mic on for us.
This way? Okay. Not quite. Section 3, without getting right into the RSA, the way I remember it is 540-A:3 defines what's prohibited. 540-A:4 talks about what the fees will be. So you could leave this in A:3 and address the amount of the fee in A:4. That would be the way to do it. Or just move this to an entirely different section. And I couldn't tell you what other section to put it in, but A-3 defines what's prohibited, and A-4 talks about exceptions to the fees. And if you don't put in exceptions, then the fee becomes $1,000 per day, which of course is, unreasonable, totally unreasonable. So it'd take a little bit of research to do that language exactly right. And if you want some support on that, I'm sure that my team can easily give you some guidance on that.
Okay, so the text of this language is fine. You're just now concerned about the location of it.
Well, I don't know how much time you want to give me, but if you take out documented administration costs, then that means you're not allowing
We're not taking it out. We're going to add reasonable.
That's not what I heard. I heard take out the word documented.
Move the word documented up a few to in front of the word background.
So actual cost of the documented background check, credit check, and reasonable administrative costs.
That sounds okay.
That's what I was, okay.
Yeah, I have to run it by my team, but that sounds okay.
Okay, so to be clear, the location is the only concern here, so we can move this somewhere else.
You could. I don't know how complicated that'll be. It might be logistically complicated in the RSA because A:3 is the section of prohibited.
Okay. Does anyone have any language recommendations to cover this penalties area?
I was going to say perhaps we should talk to a lawyer at OLS or something
Yeah, that might be a
about
good
the
idea.
appropriate section.
Okay. So I'm going to ask the committee with those changes, if those are made, is everyone comfortable voting on an amendment?
Like what we just discussed
What we
and
just
knowing that we
discussed.
have to figure out the proper section? I am.
Yeah. Okay, is there anybody, do we need to vote? We don't need to vote. Is everybody okay with this change?
Yeah.
Okay,
Aye.
great. All right, so Representative Reed, do you want to take a stroll with me? Yeah. Okay. Lovely. What a great end to the day. All right, is there any other business? Okay, great, we're adjourned. Thanks.